Hi, and welcome back to Law Talk NH Unfiltered. I'm your host, Brian Stone, a practicing attorney here in New Hampshire. Thanks for tuning in again. Today, we're diving into a topic that a lot of people have questions about: arrests. What does it really mean to be under arrest? When does it happen? And what are your rights if you find yourself in that situation? I'll break it down in simple terms, share some examples, and hopefully clear up some confusion around this important part of the legal process. So let's get into it. So let's talk about what it actually means to be under arrest in New Hampshire. An arrest isn't just when you're put in handcuffs or read your rights. It happens when you're either physically taken into custody, and from that point on, you're under their control. You're not free to leave anymore, and you're being held to answer for a crime. Now, not every interaction where the police stop you means you're under arrest. Last episode, we talked about Terry stops, those temporary detentions based on reasonable suspicion. An arrest is a step beyond that. It's a more serious kind of seizure because it's not just about checking something out quickly. When you're under arrest, the officer believes there's enough to formally charge you with a crime, and they're holding you until they can bring you before a judge or a magistrate. Here's something that surprises a lot of people. You don't need to hear any magic words, like "you're under arrest," for an actual arrest to happen. The police don't have to say anything special, and they don't even have to formally charge you in that moment. What really matters is the situation itself. What's actually happening? Whether or not you've been arrested is judged by the objective facts and circumstances, not just what the officer says or believes. So even if the officer didn't intend to arrest you, the court might still find out that you were legally under arrest if a reasonable person in your shoes would have felt like they were being held in a way that's consistent with an arrest. Think of it this way. If you're being physically restrained or clearly not allowed to leave, and the situation feels like you're being taken in for a crime, that's probably an arrest, whether the officer calls it that or not. Now, here's where it gets a little more nuanced, especially when we're comparing an arrest to a Terry stop. Remember, from episode 1, a Terry stop or an investigative detention is a brief seizure that doesn't require full-blown physical restraint. In fact, you can be seized for legal purposes even if you don't actually comply with the officer's orders. But when we're talking about an arrest, there's a key difference. You're not considered under arrest until the police physically restrain you, or you voluntarily submit to their authority. Let me give you an example from a real case. Police suspected 2 people might have stolen some furniture, but they didn't have enough probable cause to arrest them yet. So they told one of the guys, "You've got 2 choices. Either we arrest you now, or you can bring the furniture to the station while we look into it." The guy chose to bring the furniture in, and only after he did that did the police find more evidence and formally arrest him. Now, even though that sounds like the guy's freedom was limited, he didn't technically get seized under arrest until the officers actually placed him in custody. That's the legal line. Giving someone a difficult choice or even pressuring them isn't the same as an arrest, unless they're easily physically detained or clearly submitting to being taken into custody. So, what if no one ever says the words "you're under arrest"? Does that mean you're not actually under arrest? Not necessarily. Again, the courts will always look back to the totality of the circumstances. And here's where it gets interesting. Even if things start as a basic Terry stop or just a conversation with the police, the situation can evolve into an arrest if the dynamic changes. Like, let's say it starts out casual, but then the officer's tone shifts. The questions become more pointed, and you're being grilled for hours with multiple officers cycling in and out. That's not just a conversation anymore. At some point, a judge could look at that and say, "Yeah, that was effectively custody," even if they never said the words. It's a reminder that actions matter more than labels. Just because no one says arrest doesn't mean you're not under arrest in the eyes of the law. All right, let's talk about what makes an arrest lawful, because not every arrest automatically checks that box. For an arrest to be legal, the officer needs to have probable cause. That means they need enough trustworthy facts and info to make a reasonable person believe that 1, a crime was committed, and 2, the person they're arresting is the one who did it. So it's not enough for an officer to just have that gut feeling or a vague suspicion. They've got to have something solid, facts they can point to. If they arrest you without probable cause, then the arrest is unconstitutional under both the US and New Hampshire constitutions. And any evidence they find as a result, it likely gets thrown out in court. It's what we call fruit of the poisonous tree. If the tree, the arrest, is illegal, the fruit, the evidence, usually can't be used either. Now, here's something interesting. Even if the officer guesses the wrong charge, the arrest can still be valid, as long as they had probable cause for some sort of offense. So, let's say they thought it was theft, but really it was trespassing. If there was enough evidence to support either one, the arrest will usually still stand. Bottom line, probable cause is the legal foundation for any arrest. No foundation, no case. All right, so let's clear up a big misconception a lot of folks have when it comes to arrests. You do not need to be caught red-handed, and the cops don't need a rock-solid case to arrest you. They're not trying to prove guilt beyond a reasonable doubt. That's the prosecutor's job later if the case goes to trial, and we'll go over that in a later episode. What the officer needs at the moment of arrest is just probable cause, and that's a much, much lower bar. We're talking about a reasonable belief based on facts they've gathered that a crime was committed and you probably did it. That's it. It's not proof. It's not airtight. It might not even hold up in court, but it's enough to justify making the arrest in that moment. So if you're in that situation, don't waste your breath arguing about how they don't have a case or can't prove anything. That's for court. Probable cause doesn't require that level of certainty. And that's why fighting your case means knowing when to argue and where to argue it. And usually, that's not on the street. Now, let's talk about arrests with a warrant and why that matters. So an arrest warrant is basically a judge's written order saying, yep, go arrest this specific person and bring them to court. The police don't need an arrest warrant in every case. They can arrest someone without one if they have probable cause. But there's definitely a strong preference for doing it with a warrant when it's possible. Why? Because a warrant means a neutral person, the judge usually, has already looked at the facts and decided there's enough to justify the arrest. That adds a layer of protection for your rights. It's not just one officer making the call anymore. A judge had to sign off. And if your arrest ever gets challenged later, say in a motion to suppress evidence in court, the court is more likely to find it valid if it was done with a warrant. So from a legal strategy point of view, prosecutors and police are usually in a stronger position if the arrest was made under a warrant. It helps them preserve the evidence and keep the case intact. The U.S. Supreme Court has even said that whenever it's practical, cops should try to get a warrant because it strengthens their case and helps show that probable cause really existed. So while a warrant isn't always necessary, it definitely brings some legal muscle behind the arrest. In New Hampshire, an arrest warrant can be issued by a few different types of judges, like a justice of the peace, or judges from the Supreme, Superior, or Circuit Courts. The key is that the judge has to be neutral and detached. Basically, someone who's not involved in the case and can objectively decide if there's probable cause. The warrant can be for someone charged with a crime that happened here in New Hampshire or for an offense that's prosecutable in New Hampshire. Once issued, the warrant is directed to the sheriff of any county or any police officer. And here's the important part. It's got statewide effect. So, the person can be arrested anywhere in New Hampshire on that warrant. Also, even though it's not spelled out in the statute, officers like state troopers, conservation officers, and agents of the New Hampshire Liquor Commission are considered ex officio constables. That means they're legally allowed to carry out these arrest warrants too. So it's not just local cops who can make the arrest. A wider range of officers have that authority. One interesting thing about arrest warrants in New Hampshire is that the officer making the arrest doesn't actually need to have the physical warrant on them at the time. What matters is that they know there's an active warrant out for the person. That said, if the person being arrested asks to see the warrant, the officer has to show it to them as soon as it's reasonably possible. So the key takeaway is the officer's knowledge of the warrant is enough to make the arrest valid, but the person still has the right to see that warrant pretty quickly after they're arrested. One important thing to understand is that the law actually requires you to submit to an arrest and not resist, even if the arrest is unjustified. That means you have a legal duty to comply and not use force or weapons against the officers, no matter whether you believe the arrest is right or wrong, even if it actually is wrong and an invalid arrest legally. I know that can feel unfair, especially in a state like New Hampshire where personal freedom means a lot, but resisting an arrest not only puts you in danger, it can also lead to additional criminal charges. So even if you think the arrest isn't justified, the safest and smartest thing to do is comply calmly and let the courts sort it out later. Here's a fun and maybe surprising fact about New Hampshire law. If a police officer needs help while making an arrest, they can actually require a bystander to assist them. And if you don't comply with that request, you could get what's called a violation. Think of it as kind of like a ticket. Now, these violations aren't crimes. They're handled in criminal court, but are more like minor offenses. Of course, if you're faced with this situation, you might have to make a judgment call, balancing the potential risks of helping out with the fact that not helping could cost you a fine. So yeah, it's one of those quirky New Hampshire laws that most people don't think about until it actually happens. All right, here's an important thing to know about arrests and homes in New Hampshire. Generally, police can't just walk into your house to make an arrest without a warrant. If they do have an arrest warrant, they can enter the home of the person named in the warrant to take them into custody. Simple enough. But here's the catch. That warrant doesn't let them barge into someone else's house where the person might be hiding. If the suspect is at a third party's place, meaning somebody else's residence, the police need two things: the arrest warrant and a search warrant to legally enter that home. Why? Because while the arrest warrant removes the suspect's privacy rights, it doesn't wipe out the rights of the homeowner or tenant whose place it actually is. So the police need probable cause and a search warrant to enter someone else's residence. Of course, there are always exceptions. If someone with authority consents to the entry, or if there's an emergency, like a threat to safety, or they believe someone's destroying evidence, then the police can enter without a warrant. So it's a balance between protecting individual privacy and allowing law enforcement to do their job. Another key rule when police come to your door without a warrant is the knock and announce requirement. Basically, in New Hampshire, the police have to knock, announce who they are, and give you a reasonable chance to answer before they can break in. This applies whether they're executing an arrest warrant or a search warrant. The idea behind this rule is to protect people's privacy and safety, so the police don't just barge in unexpectedly, which can be dangerous for everyone involved. It also helps to avoid unnecessary property damage. Of course, there are some exceptions, as always, if announcing themselves would be unsafe or lead to the destruction of evidence. But as a general rule, they need to give you that chance to open the door first. Here's a handy tip for you. In New Hampshire, if an officer has the grounds to arrest you for a misdemeanor, those are low-level crimes, or something lower like a violation, they actually have the option to just give you what's called a summons instead of arresting you on the spot. That means you get a ticket or a court date without having to go through the hassle of being taken into custody. It's definitely something to know because getting a summons can save you time, stress, and the whole booking process associated with an arrest. But keep in mind, it's up to the officer's discretion whether they decide to arrest or issue a summons. So it's not guaranteed, and it's certainly not the norm. That's it for today's episode on arrests, what it means and how it happens. Remember, probable cause is a low bar, so stay calm and don't resist if you're arrested. Thanks for listening to Law Talk NH Unfiltered. If you found this helpful, please share it and feel free to reach out with questions or topics. You can find me on Facebook at Stone Law PLLC.